My name is Pete Mackey. I'm the managing attorney of the Sunbury office of North Penn Legal Services. Legal Services is a program which provides civil legal representation to people who are low income. I want to thank the Adams Center for Law and Society here at Susquehanna University for permitting me to come and talk to you folks. My remarks are based on my years of practice in the field of residential landlord-tenant law. They do not necessarily reflect the views of the Adams Center or Susquehanna University. As with any presentation like this, please keep in mind that the information I provide is general information. It's not legal advice. Every case is different and the law changes. So while this is meant to give you a starter on landlord-tenant law and your rights and responsibilities, and that's a point I want to emphasize, that tenants have a lot of rights, but there are also a lot of responsibilities that go with it. Your case may not fit within the guidelines of the information I provide today. Having said all that, I hope that the information will be helpful to you and also to landlords. This will be a video, be available in every public library in our service area and on the internet, and landlords can access it as well as tenants. And landlords need to be educated about their rights and responsibilities just as tenants do. Many times, more times than I can count, I've heard my clients tell me what the law is on a particular topic. They've heard it from their Aunt Betty or their cousin Bill, and I call it street law, and it's usually wrong. And I say, okay, what year did your cousin graduate from law school? And not once have I had a client say, well, my cousin graduated in 1998. So all the information they get comes from friends or relatives, and it's usually wrong. So I call my talk the 10 great myths, or maybe 11 or 12 myths of landlord-tenant law. So tonight we're going to be mythbusters, and the first myth that I would like to bust is this one. I didn't sign anything, therefore I don't have a lease. I hear this over and over again from my clients. Probably be less likely for you to say that because probably if you're a student here at Susquehanna, you will be signing a written lease. But the myth is that there's no lease if you haven't signed something. And the truth is that a verbal lease is just as enforceable in a court of law as a written lease. Now, there are a lot of advantages to having a written lease. One of them is that if you want to stay in an apartment for a year and you sign that lease and you pay the rent and adhere to the terms of the lease, you're guaranteed you're going to be there for a year and you won't have to go looking every couple of months. One of the disadvantages is that you're locked in for a year, and if you're paying $600 a month rent and then during the winter you find out that the heating expenses are going to be $300 or $400 a month, you can't afford it. So there are pluses and minuses to a written lease, but I think one of the main pluses is that you know what your obligations are and you know what your rights are from day one. But the myth is wrong. The myth is that if you have a verbal agreement, that's not a lease. It is. And what is a lease? It's just a contract, an exchange of promises. You, the tenant, promised usually to pay rent and to behave yourselves, and the landlord promises to furnish a habitable dwelling and guarantees that you can use his or her space for a year or 6 months or whatever the term is. Myth number 2, my landlord can't evict me because it's wintertime, or fill in the reason, because I'm elderly, because I have a child, because I'm disabled. The truth is that the landlord or landlady can evict you at any time of the year if you breach the lease. If you don't pay your rent, if you trash the place, if you have a pet when you're not supposed to, there are many reasons why you could be subject to eviction. And as harsh as it may seem, you could be evicted on Christmas Eve. And so the myth that you can't be evicted when it's cold or when it's raining or snowy or when you're disabled is not true. And therefore it's important to know that you must uphold your part of the bargain in order to avoid being evicted, because nobody wants to be evicted whether it's August 25th or December 25th. Myth number 3, if my landlord wants to evict me, he has to find another place or fill in the blank. Give me a good reference. Not true. Again, Cousin Bill was wrong about this one. There's no such requirement that the landlord give you a good reference. If you've been a bad tenant and haven't paid your rent, or if you trash the place, the landlord is not slandering you by telling a prospective landlord that you were a lousy tenant. And he also doesn't, or she doesn't, have to find you another place. So if you get an eviction notice, you have to find it under your own power. So far I've just told about myths that tenants tell me. In a few minutes I'm going to tell you about several myths that landlords suffer from too. They're not immune from this because their cousins are telling them street law too. Myth number 4. My landlord gave me an eviction notice, therefore I don't have to pay rent any longer. Not true. The clock is still ticking until you actually move out. You owe rent up until the day that you have vacated the premises. Does that mean that you still owe rent if you've left your couch and your refrigerator there and you plan to go back for them in a couple days? Yes, it does. Does it mean that you still owe rent if you haven't turned the key over to the landlord? Yes, it does. Because until you give the key to the landlord, you are in possession of the apartment or the house, and the landlord is not. Once you turn over key, clean the place up, get your stuff out of there, then you've vacated the premises, and at that point you don't owe any more rent unless you've signed a lease, 12-month lease, which is typical. You want to move after 8 months, something's happened, you got a job offer, whatever the reason, you don't want to stay there for the remaining part of your lease. You're still obligated to pay the rent. The landlord may have a duty to try to rent it out to somebody else and cut his or her losses, but you are on the hook when you sign that lease, and that is one of the disadvantages of signing a one-year lease. You're on the hook for the full 12 months. Myth number 5, the eviction notice isn't notarized or witnessed, therefore it isn't valid. Or I've heard the eviction notice hasn't been typed, or it didn't come from an attorney. All those are false. They're myths. An eviction notice can be written on a paper plate. In fact, I did have a client who brought in an eviction notice written on a paper plate. And that was a valid notice. It said, we'll pretend the person's name was Smith. It said, Smith, get out by December the 10th. That was a valid eviction notice. It's crude, but it was valid. It doesn't have to be typed. It doesn't have to be notarized. It doesn't have to come from the sheriff or the constable, and it certainly doesn't have to come from an attorney. So if you get a piece of paper, or a friend of yours gets a piece of paper that says you haven't paid your rent, you have to be out by such and such a date, that's probably going to be a valid eviction notice. And why is that important? Because an eviction notice is required in Pennsylvania before the landlord goes to court to start legal proceedings against you. My last myth regarding tenants is perhaps the most important one I can tell you. And if you leave this room with nothing else, or if you watch this over the internet or get a DVD of it, and you get nothing else out of this, please get this. Do not ever, ever give the landlord or landlady money without getting a written receipt. And what's the myth there? The myth is, oh, well, if it becomes an issue, surely the landlady or landlord will remember that I gave them $200 on September 15th. No, they won't. They either will purposely forget that they got the money, or they will forget. And how can you prove it? How can you prove that you paid rent on October 1st or September 15th? You need proof, and if the landlord won't give you a receipt, you write out your own. All it has to say is, received of Jane Smith, $250, October 1st, 2011, signed by landlord. That's a valid receipt. Or if you give a money order, the receipt for the money order is good. Or if you pay by check, that's also good. But write a receipt. That's the most important lesson I can give you tonight. Now there's some myths that landlords have too. And I deal with landlords all the time, usually by phone. The tenant comes into my office or I talk to them on the phone and there's a dispute. And so now I have to call up the landlord and discuss the situation with the landlord. Of course, the landlord's story is usually different from the tenant's. And sometimes I wish I were a fly on the wall to see who's telling the truth. But there are two versions of the truth, and I need to listen to the landlord's version. And in listening to that, I hear a lot of myths that the landlords are operating under too. So, self-help eviction is legal in Pennsylvania. My tenant didn't pay the rent, therefore I can padlock the door, cut off utilities, throw their stuff out in the street, or I'll get the police to come and evict them. All those things are not true. The police will not get involved. They'll say to both parties, either landlord or tenant, it's a civil dispute, go talk to your lawyers. We're not coming out of our police station to help either side. Padlocking the door is illegal in Pennsylvania. It's called self-help eviction. If it happens, and just because it's illegal doesn't mean it doesn't happen. Landlords do a lot of things that they know are wrong, or they don't know are wrong, but they do them anyway. If a tenant's property if the apartment is padlocked, the tenant does have a remedy, and it's called an injunction. And the landlord could be ordered to open up the doors and refrain from shutting off utilities. I had one landlord who threw stuff out the window, the second floor window of the tenant's apartment, and he called that airmail. And that was illegal. But he did it. Just because it's illegal doesn't mean people don't do things that they shouldn't do. But when I'm talking on the phone to the landlords, I try to get that across to them. They can't do that. There's an orderly legal process if they want to evict. And even if they have good reasons, they still have to give the eviction notice, file a complaint in magistrate's court, and go through that process. So there's an orderly process which gives the tenant, should give them sufficient time to get their act together and move. And it also requires the landlord to follow that process. So the landlord will get in a lot of trouble if they engage in self-help eviction. If, and only if, a tenant knows that it's illegal and contacts a lawyer about it. Because things can happen, and if one side, the side that it's happening to, doesn't know it's wrong, they're going to let it slide. Another myth from the landlord's point of view, I don't need to get a court order, the police will help me move the tenant out. And as I just mentioned earlier, the police will not take one step to help the landlord. They'll tell the landlord you have to go to the magistrate and file a complaint. A lot of landlords think the police will help, or they think the sheriff will help, or they can get a constable. Not true. They can't get any help until they get a court order. And they have to go through these steps. They have to sue, have a hearing, wait for an appeal period, and then, and only then, will a constable help them padlock the place and get the tenant out of there. Another landlord myth is, I don't need to fix the furnace, let the tenant do it. I don't need to fix the furnace because the tenant didn't pay rent in December. I don't need to fix the furnace because it's not 32 degrees in the apartment, it's only 45 degrees in the apartment. I don't need to fix the furnace because it's too expensive. Or any other reason you can think of. These are all myths. The landlord is in business. They're in the business to make money, and they do this by renting out their property that they own. But they have to provide what's called a habitable dwelling. In the Commonwealth of Pennsylvania, every residential property must be considered habitable. Does that mean that the code officer goes through every apartment, inspects it, and gives it a certification? It doesn't mean that. What it does mean, though, is if there are problems with the apartment and the landlord won't fix them, the tenant has a right to either fix the property himself or herself deduct the cost of the repairs from the rent. They have the right to break the lease and move, or they have the right to go to court and try to force the landlord to make these repairs if it's something serious like a furnace. Furnace breaks down in August, it's not that big a deal. The air conditioner breaks down in December, who cares? But if the furnace breaks in December or the air conditioner breaks in August, those are big deals, and they may render the place uninhabitable. Another myth, I don't have to return the security deposit because there were some small holes in the wall or some marks in the carpet or whatever else you want to say. The test there is whether or not damage is done where reasonable wear and tear. It's pretty hard to live in a place for a year or so and do nothing to it. If you walk on the carpet, you're going to diminish the value of the carpet. If you put some pictures up, you might put a small hole in the wall. The test is what's reasonable under the circumstances. Ordinary wear and tear should not result in your security deposit being withheld. It's your money, not the landlord's. I guess that's another myth. Once that money goes from your hand to the landlord, it's almost human nature that the landlord starts to think it's his or her money. It isn't. It's your money. They're holding it in trust for you until such time as you move. If you move owing rent, if you move having done serious damage to the place, if you move without cleaning, if you move and you leave a broken sofa, all those costs can be deducted properly from your deposit. If you don't do any damage and you clean the place, so on and so forth, and you return the keys, you're entitled to get your deposit back. If the landlord doesn't return your deposit within 30 days and you've given written notice of where you're moving, you can sue the landlord for double the deposit. Another myth, I can go into my tenant's apartment anytime I want. I own the place. This often happens when the relationship has deteriorated to the point where they're fighting. There are three circumstances, I think, where the landlord can come in. Number one, if there's an emergency. Tenant is away at work or tenant's at school, and the other tenants in the building notice that there's water dripping through the ceiling from the place above, or there's some kind of a fire, or any other emergency. Certainly the landlord can go in then and take care of those problems. Second situation in which a landlord can go into the apartment. Certainly the landlord can come in to inspect, but it has to be after notice to you and at a reasonable time. So landlord calls at 6 a.m. and says, I'll be there in 15 minutes to inspect your apartment. That's not reasonable. You don't have to let them in. But landlord calls and says, I'd like to come next Saturday at 10 a.m. to inspect. That's certainly reasonable, and I think the landlord has a right to do that. Third circumstance, either you're moving or the landlord is in the process of trying to make you move, or the landlord's selling the building and wants to show either the building or the apartment to somebody else. Again, with notice and reasonable times, that would be okay. Landlord calls at 7 a.m. and says, I'll be over in 5 minutes with the next tenant. And you're still in bed, or you just got out of the shower, your kids are getting ready for school or what have you. No, that's not reasonable. Midnight, not reasonable. But 4 o'clock in the afternoon, sure. And here is the last myth that I have, and this is for landlords. I can rent to whoever I want and turn people down for whatever reason I want. The myth there is that there are state and federal statutes or laws which protect the rights of people so that they cannot be discriminated against based on disability, race, sex, national origin, religion, categories such as that. If somebody's disabled, the landlord has to make reasonable accommodations for that person, and certainly cannot reject a person because of their race or the other categories I mentioned. A lot of landlords don't know that, and this applies not only to renting an apartment but to advertising. So if you see an advertisement that says no pets allowed, that's okay. But if you see an advertisement that says, addresses one of those categories, that would not be okay. I hope that this information is helpful to you in your future dealings, because many of you at one time or another will be a tenant. Maybe some of you will be landlords too. But hopefully this information will help you avoid some of the pitfalls which many of my clients fall into. Thanks very much.